Good afternoon, everyone. Welcome to the webinar on mediation, a way forward organized by Knowledge Teas. All of you are requested to turn off your microphones. Questions would be taken up after the session. The speaker for this afternoon would be Mr. Sameer Shah. Mr. Sameer Shah is a well-known international arbitrator, advocate, and mediator with over 2 decades of practice. He is the program director of the Indian branch of Chartered Institute of International Arbitrators, London. He has been associated as a panel mediator judge and mentor with different teams participating in William C. Wiz International Commercial Arbitration Moot Court Competition and international competition at Shanghai, China. Mr. Shah regularly conducts training courses for CIAB India at Mumbai, Delhi, and Chennai for training professionals as mediators. He was invited by the Commission under chairmanship of retired Justice B.N. Sri Krishna, Reforms in Arbitration Practice and Law in India. He is the chairman of International Dispute Resolution and Risk Management Institute, Hong Kong, India branch. Adjunction Senior Lecturer at Academy of International Dispute Resolution and Professional Negotiation, Hong Kong. He is a panel arbitrator in Court of Arbitration for Art, Netherlands, and Mediator Mainland, Hong Kong, Joint Mediation Center, and the Mediation Center at Dubai. Apart from that, he has his own proprietary law firm at Ahmedabad, state of Gujarat, India, under the name of style of S.U. Shah and Associates. Recently, he was made the senior partner, Trust Legal Ahmedabad office, having main office at New Delhi and branch at Kochi. He actively promotes mediation for ADR in India, Hong Kong, and Nepal, conducting training and workshops for mediation development and also giving coaching to students and other professionals on mediation and advocacy skills for it. He is currently promoting online mediation training and proceedings. Having legal associates undertaking the work entrusted to them throughout India and international associates at Dubai, Hong Kong, Malaysia, Saudi Arabia, China, London, Canada, and Vietnam. I now request Sameer sir to start with this session.
Thank you, Megha, for that brief introduction, and good afternoon to most of the participants here. I must thank Megha personally for giving me this opportunity to share my thoughts on a very important subject, especially in the current scenario. And I have been, in fact, I have conducted a couple of other webinars on the same subject, but today, the topic which is given is something which is very relevant for most of us. So, thank you so much, Megha. And let me now start today's presentation. What we have been hearing, and now it has become a sort of common parlance word, is alternative dispute resolution. Now, when we talk of alternative dispute resolution, the first thing which comes to our mind, why we are talking of something alternative, and it is alternating to what? Well, of course, alternative to the traditional litigation or the court processes. But the reason being, why at all we are, discussing about something alternative, and that too for dispute resolution. So before we actually understand that, we need to understand why we are talking of this, why there is a need for alternate, to find out an alternate to dispute resolution. Now, before we do that, I think we must understand why there are dispute assets, and or what is dispute for that matter, because we tend not to appreciate the basis of why there is a dispute, and this actually becomes the core of resolution or whatever form you choose it. So let us first understand dispute, and before we do that, according to me, what we need to understand and appreciate is what we call conflict. So what is conflict for that matter? Now, I would just like to pause here, and Megha, if we just give 30 seconds to the participants in the chat box to just give their short answers, what they understand by the word conflict.
Sure, sir.
Quick quick, this thing response. 30 seconds. That's it.
Sure, sir. Participants can type the answers in the chat box. So one of the answers we've received is conflict is disagreement.
So I think yes, I could see majorly what is being proposed is disagreement. Well, in a way, yes, there are disagreements which obviously lead to conflict. But what actually happens in disagreement? Now, disagreement can happen because of differences of value propositions, opinions, needs, interests, thoughts, attitudes, understanding, and so forth. So ultimately, you see, there is a sort of uh, uncommonness, or people are not, the two parties may not be able to come to a single acceptable conclusion to one particular issue. So yes, I understand. I mean, most of you who have sent their responses are very correct, saying that there is a disagreement. So conflict basically is sort of difference or disagreement between two parties. Now, you see, conflict is nothing new. It happens everywhere in a day-to-day life. It may be in coming in variety of forms because of, as I said, different needs, customs, miscommunication, which is one of the major factors of conflict as such between the parties. So, so this is what uh, his conflict is all about. All right, now, but we are talking of dispute resolution. We are not talking of conflict resolution. So let us now understand what is what is dispute for that matter. So we just went through, we understood what conflict is. So let us not also understand what dispute is. I mean, is there any difference? Because that is the reason we said dispute resolution. We don't say conflict resolution. So there must be some difference. So what is that? Again, 30-second window to give your three thoughts on what do you understand by dispute.
Participants are requested to kindly write their answers in the chat box.
All right. Let me just put it in a very simplest of form to understand. A dispute is obviously a conflict, but it is coupled with assertion of legal rights. Then only a conflict turns into a dispute as such. When a party, or both the parties for that matter, asserts their legal rights into it. Now, just to give an example, just try to visualize a simple commercial dispute, which basically revolves around account reconciliation. What happens in account reconciliation? If there is a supplier and buyer transaction, and it is going on, let's say, for some time, so there would be a running account between them, debit and credit, and therefore, at the end of, let's say, a quarter or maybe a year, they would normally reconcile their accounts to find out if there is any differences in that. Now, till the time they are doing this, it might have it might reach just to the state of conflict, in the sense that one party would say that this, okay, as from, let's say, the supplier would say that as from my accounts, this is what is it's showing as of now, debit or credit, and the buyer would say, no, this is as per my account, this is what the position is of that value. So far, what they are discussing is about the positions of their account. But the day or the stage at which either of them, let's say, put up its legal right or start claiming from the other side, that's where the dispute arises, provided the other party opposes to that. If the other party agrees, then there is no dispute. But as we said, since this is already a disagreement between two parties, and then coupled with a legal assertion of legal right of maybe a reference or a claim for that matter, that's where it turns, that conflict turns into a dispute. So therefore, what we just saw is conflict plus assertion of legal rights, converting it into a dispute. And that's what we are dealing here today about dispute resolution, one form of dispute resolution. Now, why I'm making you go through these basics is because this is the basis of any dispute resolution mechanism, more so for mediation. And I'll come to that why I'm pressing for all this basic understanding, because that's what we tend to normally ignore or understand and appreciate. Therefore, what we just discussed is, or what I just presented before, is a conflict is more related to personal issues, and dispute would be more tend to be legal for that matter. Now, when we are talking of conflict and dispute, what normally happens? If there is a dispute, what normally we do? I mean, what normally a party would do? They try to discuss amongst themselves initially. If they are at not a very high level or escalated level of dispute, then there would be a series of what we call negotiations. And what happens in negotiation? They will back and forth exchange, which is what we call as communication. So normally, the parties would resort to negotiation through means of communication to try to resolve their dispute. So negotiation is basically what? It is the fundamental root of solving this dispute between the parties. And in negotiation, what we do is communication. So if we just try to understand what communication is, so communication is a process in which one person tries to share a common meaning with the other person. That's what we normally do. A good communication is all about. Now, so this is what basically happens in any dispute before it actually goes into a particular forum of resolution. So parties are trying to, I mean, this is any day-to-day issue, maybe between friends, between, parent and siblings, brother, sister, any relation for that matter, be it commercial or personal. There's always back and forth exchanges, communication happening. And ultimately, it may be the purpose being possibly to come to a common ground of understanding for resolving the dispute. Therefore, now this basically leads us to the main, background for what mediation is all about. When we're talking of mediation, it is more to do with, interactive communication than what it can happen in any other mode or form of ADR as we know. And therefore, when we say mediation, what we actually mean is, according to me, mediation is a dynamic, structured, interactive, and voluntary process of dispute resolution where an impartial, neutral, third person or intermediary facilitates the parties to reach a voluntary, mutually acceptable, and amicable resolution of either all or some of the issues in dispute. Now, please try to understand some very basic words which I have used to define what mediation is about. So what I just said is it's dynamic and structured. Now, when I say it's dynamic, because why I'm saying this is because, as I said, It is more informal. It is interactive. There is the parties are free to communicate with each other amongst themselves with the mediator, whatever they feel, whatever they actually want to say. There are no restrictions as such compared to what happens in arbitration or in court of law. So it is more dynamic. When I'm saying structured, it is a sort of, in my opinion, sort of, what do you call, something opposite to what we normally say when we are saying it's informal. Then how can there be a structure? Well, it is like this. Imagine there are, expert musicians sitting in a room, and each one of them are expert in respective instrument they can play. Now, if they are allowed to play at their own will, what will happen? You will not get a melodious outcome of that. But once there is a person in charge, the conductor is there, then definitely we get the best of the symphony. This is exactly why, in spite of this being an informal process, we need a structure to it. In sense of at least some process has to be laid down when we're talking of how to conduct a mediation. And therefore, it is dynamic in the sense it is open, it is interactive, it is informed, but structured in a way to achieve the final purpose of at least trying to resolve the dispute between the parties. So, in a nutshell, just to briefly, this what mediation is, and the basic, what do you call it, ingredients of mediation. Well, it's private, it's confidential, more confidential than arbitration. Of course, it's voluntary, and it is non-binding. Now, this is another important aspect of mediation. When we talk, it is non-binding, which is both an advantage as well as a disadvantage of why mediation is at a stage what it is right now, especially in our country. I'll come to that later, but just to make you understand that since it is non-binding, it should be taken as a more advantageous process for party to come and sit together and try to resolve their dispute. Now, when we are talking of mediation, so what actually is different? Now, before we go into that, difference in the sense of what is the difference from other dispute resolution process, arbitration for that matter, or litigation for that matter. So, just briefly, a very quick go through of what mediation, how it works, what you do in mediation. Many of you would have, have the experience, may have also conducted themselves, or may have taken the training, have been remote or whatever. But just to quickly, understand what this process is about, how it is conducted. First, of course, there has to be a party consensus to appoint a third party neutral person to be a mediator. They will have a first initial preliminary meeting where the mediator, if the parties are not known about the process, then the mediator will definitely explain, and the mediator must explain the process to the party, how it is going to be carried out. The rights and the whole process is being laid down. The timetable is being laid down of course, with the consent of the parties. It is very much similar to what we do in arbitration in the prelim meeting. And then what happens is the first phase of mediation starts, which is listening. Now here, the mediator is simply a listener, and that too an active listener as such, to understand the respective cases of the parties. So mediator is just at this stage listening. Then comes an important stage of framing of issues. What normally call, that's a language what we use in court of law, but what we say is outlining of issues in mediation, just to make it different from court and to make it different from court. Now, when a mediator is trying to outline the issues of the parties based on the listening, what mediator is actually doing is trying to reframe and trying to seek clarification from the parties whether the mediator is able to understand what the parties correctly, in the sense whether the mediator is able to understand correctly what the parties have put forward their cases all along. This is where the stage, I mean, the critical, what do you call, function or position of mediator comes to play because a mediator here has to first obviously understand, not identify not only the issues, but also to understand the reason behind those issues. That is very important, and that's why we went into the basics of conflict, dispute, why there are conflict, why there are disputes, what is all this about. So when you are going into why question, that's what, then only you can come to a solution. So this is exactly what a mediator is supposed to do at this stage of identifying the issues and also understanding the reason behind those issues. And then comes another critical stage of mediation, which is actually the mediation. And that is where the mediator would then discuss either personally or amongst the parties and the representatives about various issues and probable alternatives to that. And that is where what we know as what caucus comes into play. Caucus means private meetings between the mediator and one party, where the parties can openly discuss with mediator what they want to say, which they may not like to share at that stage with the other parties. But at least it is important for the mediator to understand what is the issue between the parties are. All right. So this is a very, very important stage of mediation. And then through further negotiation and discussion, the mediator would then try to make the parties come to a settlement of issues. So this is in nutshell what actually happens in a mediation process. It is very, very easy, very quick to just describe it, but it is very, very intensive when you're conducting mediation, because mediation is more to do with psychology of parties rather than the law or structure or processes as such. And that is why it is much more difficult than arbitration or litigation, because you as a mediator are not supposed to do any judgment on the case of the parties. You're not supposed to even suggest or finally pronounce any judgment on the issues, but you have to still, by listening, by discussion, by communicating, you have to facilitate the parties to come to a resolution, and that is very, very difficult. But that is exactly what mediation is about, and it is, though it is difficult, but it is still doable, workable, and I would say one of the best right now alternatives for dispute resolution. So what happens is in mediation is, let us understand in through this concept of difference between sympathy and empathy. When I say that, I say that in mediation you have to work with more empathy rather than sympathy. So what is sympathy? Sympathy is something when you're feeling, let's say, I'll just give you an example to understand these two words. What happens after death of a person in a prayer meeting? I mean, people attend that prayer meeting just to sympathize, all right, with the deceased family. So that's a sympathy. But when that sympathy is added with the emotion, in the sense that you feel the way the other party is feeling and understand and appreciate those feelings, that is what is empathy is all about. And that exactly is what mediation is all about. Fine, you can be sad as the other party sad, but if you are trying to understand the feeling of the other side, why that person is so sad, I mean, forget about the death, but in general, or why that person is saying the way that person is saying, that is where empathy comes into play. And that's exactly what's required in mediation. So you have to be more empathetic than sympathetic in mediation. And this all will come back, I will relate this back to the topic. What we are discussing today is the way forward. Now, I'll come back to this. Just keep in this mind the difference between sympathy and empathy, and it's important in mediation. So now we have basically understand what mediation is and how it works. The question right now is, if this is so, then what is actually holding it back? Or where is the issue in our current system? What is holding it back? let's say talking of the court of law or litigation or traditional dispute resolution mechanism, what is happening there? You see, what is happening basically is to do with the general mindset of the people. We normally have this mindset, and we, when I say we, it is both the parties as well as the lawyers for that matter. Everybody generally has this kind of a perception in mind that if, let's say in a dispute, we make some proposition, if we try to settle it out, it will look as if we have a weak case. It will give an impression to the other side that we have accepted the loss, and we are just trying to we are trying to surrender. That's the normal mindset, and that's why people, and including the lawyers, don't advise parties to settle, rather than they would just try to go on with the fight, with that dispute. So this is basically is what is the issue, why the traditional dispute resolution system of our country has to an extent failed, and that is why we have we read that there's so much of backlog in our court. Though there are other reasons also, but this is one of the prime reasons why people are not trying to adopt to a new system of dispute resolution, especially mediation. Because this is the fear in their mind. This is their perception in their mind that the other party would take advantage of their position. But and that is why mediation comes into play as the most important factor. So what we really need is changing this mindset. We need to change the mindset, look towards mediation as the appropriate dispute resolution mechanism. And when I say that, why I'm saying this is because, as we just discussed, mediation is informal, it's more open, it leads to confidence building exercise between the parties, and where a focused discussion is happening between the parties on a particular issue. Through mediation, parties are able to better understand the emotions, their respective emotions, needs, interests, feelings, and position. Now, at this juncture, let us also understand this concept of interest and position. What is this interest and position issue? Now, when we talk of interest and position, it is basically the issue of what and why. Now, those of you who have gone or have read jurisprudence, they would able to relate to this, what I'm just discussing on what and why. When we are talking of position, it is more related to what. When we are talking of interest, it is more related to why. And that is what is important. Interest, the mediation takes care of focus. Focus is on interest rather than position. And therefore, just to, if I just in nutshell, in brief, summarize the importance or the advantages of mediation is like this. Are these. First, it reduces conflict and fosters fraternity. Second, it improves relationships, at least, and maybe not improve, but at least it maintains relationships between the parties. Now, here, let me just give a very relevant quote to better explain this statement. And the quote is, a successful relationship is based upon two important factors: finding similarities and respecting differences. This is exactly what happens in mediation. Third, mediation reduces tension and spread peace. Now again, let me just give another very relevant quote, two quotes here to better explain this. The first one is, conflict is inevitable, as we just see and getting every day, but combat is optional. And the second quote is, be selective in your battles. Sometimes peace is better than being right. Now, we can better understand this if I give you the current issue of what is happening between India and China at the border, or for that matter, what has been always, since time, since history of post-independence happening between India and Pakistan. In spite of, we know that we are right, we are still adopting peace. And we are actually reaping fruits for that also to an extent. So this is what happens in mediation also. You may be, the parties understand their position, whether they are right or wrong. But still, they try to work around a sort of solution which is win-win for both the sides. And that is what this particular quote also says. Sometimes peace is better than being right. All right. And the last, but not the least, advantage of mediation is it reduces cost and time. Obviously, it's nothing to explain about. And of course, it provides flexibility in solutions. Now, as we understand, mediation is much more to do with the feelings, personal aspects of the parties rather than foreign law. Therefore, there's always room and scope for flexibility in finding of the resolution to the dispute in mediation. Now, having said that, what is the situation right now in our country, for that matter, of mediation? Whether we are ready for, whether we have been able to take advantage of all these aspects, of all these advantages, what I just mentioned about mediation, for the benefit of society at large. So, but before I do that, I would just like to make a quote of the observation of a retired Chief Justice of the US Supreme Court. And what he observed, so far as the litigation part is concerned, is what he said, that traditional litigation is a mistake that must be corrected. For some disputes, trial will be the only means, but for many claims, trial by adversarial contest will end up like a battle. Our system is too costly, too painful, too destructive, too inefficient for really civilized people. Now try to understand and appreciate the meaning behind this observation made by US Supreme Court judge, but it is equally relevant for our country also. So what is the position in our country right now? Now, if we look at that, see, even now we do have certain laws and provisions of law which as such provide for inbuilt mediation. And just to give you a few examples of such laws. One is, of course, the Industrial Dispute Act. Secondly, Companies Act, the 2013 amendment which has happened. Then the MSME Act, of course, RERA. So all these laws are already promoting mediation. They already they are inbuilt. The mediation is inbuilt in these laws, for that matter, for dispute resolution. And even if you see in 2018, we had amendments in the Commercial Courts Act, where now mediation has become a mandatory aspect before litigation before the case or suit can be filed in the court, especially, I mean, though it is restricted only to commercial disputes, but it's a very, very important step for promotion of mediation. So, this is a position in India. Of course, from the international perspective, we are one of the first signatories to Singapore Convention, which is akin to similar to what New York Convention is to arbitration. But in spite of that, uh, I feel, in my view, we are still way behind other jurisdictions like Ireland, Singapore, Hong Kong, for that matter, so far as mediation is concerned. These jurisdictions and many others have already do have a mediation law um, in their respective countries. Though we have just proposed, and there is a committee set up to look into to frame mediation law. But apart from that, there are many other factors, which need to be looked into, and to see that mediation is followed, adopted, and referred to in much bigger way than what it is now. And as I said earlier, the main issue is the mindset of the stakeholders. And as I said, it includes both the parties as well as lawyers, including the government and judiciary, all together. We need to change our mindset towards resolving dispute as such in a general and broader way for that matter. Secondly, awareness. We need to have awareness spread across all levels of society about mediation and its benefits and advantages. Now, it has to also start not only with higher education, but from the schools itself, from the kindergarten itself. I was actually discussing this aspect with a couple of my colleague friends in US uh, during the current issue of racism which has happened there. So one of the solution, or one of the suggestion which I propose and which even others also agree to, is education, proper education to all, right from kindergarten to higher up, including the judiciary, towards the issues in society. Well, we were both talking about racism, but it equally applies for mediation as such. So education is another, awareness is another aspect. We need proper and good legislation for promoting mediation. In fact, the lawyers like us must also appreciate mediation and its advantages, and should also equally inform our own clients about it before resorting to the traditional litigation process. And of course, we need trained, qualified mediators. Now, today, what is happening in our country is we don't have that adequate pool of trained and qualified mediators. What we see is mostly the lawyers or the retired judges who are donning the cap both as an arbitrator or as mediator. But as I said, it may be true in arbitration, but I don't agree that you need a lawyer or a person with a knowledge, essential knowledge of law, or a judge to sit as mediator. You need to be more proficient in basic human understanding, human psychology, and other subjects rather than law to be a good mediator. And that's what mediation is all about. It's more to do with natural law, natural justice, rather than just pure law, codified law for that matter. So where does it, now what do we do now? If we talk of the current position for that matter. So where do we stand? Because what we have to, and what the topic says, is mediation the way forward. Now let us understand, is it the way forward? To me, yes, definitely it is the way forward. And we just saw why it is the way forward. I was reading actually a very interesting collection of articles which is in form of ebook, which is titled as Living Together, Separating, Divorcing, Surviving During a Pandemic. Though that this particular book is more related to family law perspective and issues related thereto, but the one particular article there is equally generally applicable to the current situation. And what it says, what the authors there says is that today everybody is suffering tremendous financial and emotional loss and stress. So what do we do? Is there any way out? Well, of course, yes. The answer, of course, yes. There is. There is not one. There are many ways out. But the problem is we are not able to find that way out. So what do we do? The reason being we are not thinking properly. We are not that focused. Or rather, what the authors actually say that we should not be so focused as of now. In fact, our thinking should be broad based. You know, we should not be right now focused on one particular issue, but the reason what they say is, and that is very, very interesting, because it says that focus and being efficient kills diversity. What we need right now desperately is diversity of options to find our way out. Very, very interesting observation made by the author, and it is important in current situation. We need to have a very broad-based, non-adversarial approach and thinking to the current situation, and that can happen only in mediation. Why? Because it is, as I said, it is more informal, it is open. This is where the confidence building happens between the parties, and that exactly is right now the need of the hour. In one of my another webinar, this is exactly what I you know said that today people have lost faith, trust, hope, because of the pandemic situation. And the first and foremost thing which is required right now is to start confidence building exercise, and that can happen, and it has to do by individuals himself or herself. You see, so we should not lose hope because this is not the end. Understand, this is not the end. The world is not going to come to an end. It's just a temporary phase. Of course, it's serious, but yes, this is not the end. So we must look from a very positive perspective. We must adopt a very holistic and human approach to every dispute right now. Now, here, let me give you a simple example. And many of my clients have also, approached me on my view and opinion on the current tenant-landlord issues pertaining to rent payment. Now, you would know that the Ministry of Home Affairs have come up with a notification somewhere in I suppose end of May or March, I suppose March or in April, uh, saying that the tenants should not be evicted on the ground of non-payment. Now, understand the issue what is led to. Today, those tenants also who are able to pay or who has the capacity to pay are not paying, taking advantage of this notification. At the same time, understand the plight of landlords. There would be landlords, of course, there are many landlords who can still survive if the tenants are not paying, let's say, for 2 months. But there are landlords for whom rental income is their bread and butter. They're surviving on this rental income for that matter. So what would happen to them? Now today, many of you would have attended so many webinars which has happened across both in our country as well as internationally on the issues pertaining to force majeure, frustration of contracts, impossibility of performances, so and so forth. But none of these webinars, some of which I have also attended, none of these webinars, none of the speakers could definitely say whether this particular condition would amount to a force majeure or not. everybody come to a common conclusion that each contract has to be read separately in its own way. Now, is this a solution? This is not a solution. The problem still remains. So what is the solution? What I suggested and what definitely a court of law would not be able to do it unless it adopts mediatory viewpoint is that let this particular rent be deferred for some time. Now understand the difference between deferment and waiver. Deferment means your liability of pay that particular amount is postponed for some time. Waive off means it is extinguished. You're not supposed to pay now. So there is a difference. What I'm suggesting, let this rent payment be deferred, let's say for 2 more months, or they may be deferred in installments, depending on, of course, negotiating between the parties. So by that way, at least both the parties will be able to survive and the relations will be maintained. The landlord will not feel the pinch of not getting the rent as such, and the tenant also will not be at the losing edge of paying in spite of not having any earnings. All right. So this solution can happen only in these kind of solutions can happen only in mediation through negotiation, not in court of law, because court of law has to work within the boundaries of law. To an extent, it may not be true in many situations, but then the court is bound by law. Mediation is not for that matter as such. And therefore, as I just told you, there would be flexibility of options, alternative solutions, and that happens only in mediation. And therefore, you can read this article on this in this ebook, a very interesting ebook, if for those who are interested in mediation as such. And another very interesting part which I wanted to discuss and which is relevant to the current topic and which would actually summarize what I just discussed is what is known as Edinburgh Declaration. Now this happened somewhere in May 2018, where some renowned mediators across 20 odd countries gathered at Edinburgh in Scotland for taking a pledge for promotion of mediation, and which then came out to be known as Edinburgh Declaration. Now, what it says in nutshell, I'll just read, and please appreciate and understand each and every pledge, which will summarize the whole discussion what I just did, and it will give concurrence to the current topic of yes, mediation is the way forward. And what this declaration says? It says that number one, we believe that it is in the interest of our world as a whole and our own communities in particular that difficult issues are discussed with civility and dignity. Second, we believe that it is very important to find common ground and shared interests whenever possible to enable and encourage people to work out difficult issues constructively and cooperatively. Third, we believe that finding common ground and shared interests requires meaningful and serious dialogue, which requires significant commitment from all concerned. Fourth, we believe that understanding underlying values and addressing fundamental needs is usually necessary to generate long-term sustainable outcomes. Further, we believe that restoring decision-making and autonomy wherever possible to the people who are most affected in difficult situations lies at the heart of good problem solving. We believe that mediators have a unique role to play in helping to promote the principles we have set above. So this is the pledge, and each and every part of it is equally important because it summarizes in a very, very concise way the importance of mediation and why it should be taken resort to especially in the current situation. It further says that what is required to be done is like this: to show respect and courtesy towards all those who are engaged in difficult conversations, whatever view they hold, enable others to have emotion where that may be necessary as part of any difficult conversation. Acknowledge that there are many differing, deeply held, and valid points of view. Listen carefully to all points of view and seek fully to understand what concerns and motivates those with differing views. Use language carefully and avoid personal or other remarks which might cause unnecessary offense. And lastly, look for common ground wherever possible. So this describes what mediation is all about and why it should be adopted in much more effective way for resolving the current situations or for that in general way all the conflicts and disputes what is happening around. Now I would just like to end with three very interesting again quotes which I hope you would appreciate. And I would say the first is: an ounce of mediation is worth a pound of arbitration and ton of litigation. Second, in court of law, you get law. Well, that's why we said court of law. So in court, we get law. In mediation, we get justice. So let's not litigate, but let's mediate. Thank you very much.
Now we're open for questions. All the participants, if they have any questions, please send them in the chat box. One of the questions is, at what stage of a dispute can mediation be used?
Well, I would say that it can be used at any stage. And for that matter, I would suggest that it should be used prior, as a tool of even conflict avoidance for that matter. So it can be used at any stage, provided, of course, as I said, the parties must appreciate and then come to a common consent. Since it's a voluntary process, it cannot be forced upon as such. Though here, I would just like to, add my thought on so far as I just initially said that, there are advantages and disadvantages of mediation being non-binding. And therefore, because it is non-binding, most of the time it is being taken disadvantage by especially respondents, to fail the process of mediation. And therefore, in my view, it should become at least binding once it has started or if it is proposed. And if the other party is refusing, then let there be some kind of punishment, maybe economical for that matter, of on that party which refuses. So in short, my answer is that it can happen at any stage. There is no bar that you can do mediation only at one particular stage. No.
The other question is, what are the qualifications of a mediator?
Very interesting. I just also did this in one another webinar. Well, as I said, as a good mediator, in my view, you must have three very important uh, qualification, and not qualification, I would say, but characteristics for that matter. One, you should be passionate about it. You should be passionate in the sense, are you of the nature of, helping others? Does helping others excites you? You know, and if that is the thing, then definitely yes, you are in for to be a good mediator. But passion alone is not good enough. The next important aspect, along with passion, you need to have an aptitude towards mediation as such. And when I talk of aptitude, it is something to do with something your inborn skill, your aptitude in those certain have this, acquire this through training, but you should have that aptitude towards, that particular, this particular kind of process. And third is compatibility, in the sense, as do you have the ability to sit with a dispute, or you get influenced or carried away with dispute? If you are able to sit without getting influenced, then yes, you can be a good mediator. So as a mediator, as I said, is a neutral, impartial for third party person. So when we talk of neutral, this is where it comes into play, that you are uninfluenced with whosoever the parties are, whatever be the subject matter, but you still remain uninfluenced, you still remain impartial, you remain neutral. If you are able to do that, yes, you are a good mediator. This, according to me, of course, there are general, characteristics, but according to me, you need not have a qualification as such, like a lawyer or a chartered accountant or a company secretary for that matter. But I think you must have this inborn characteristics to be a good mediator. You must have a good knowledge of human psychology. I think that is the prime importance for a good mediator, because you are dealing, as a mediator, you're dealing with humans. And I mean, this also goes well with even lawyers for that matter, because we are dealing day in, day out with humans. All right. So you must have basic understanding of human psychology. That's what I would say are the important characteristics.
So the next question is, how do you see the future of mediation as compared to arbitration in terms of arising dispute? And so you think, as we have the law for arbitration, mediation law, or should also be implemented?
Um, I didn't understand the last what it says. I understand the mediation and arbitration issue, but there was something related to some particular dispute, pricing dispute, they said.
I'll repeat the question, sir.
Yeah.
How do you see the future of mediation as compared to arbitration in terms of an arising dispute? And so you think, as we have the law for arbitration, mediation law, should also be implemented?
Well, I think there are two parts of it. So I'll take it in two parts, in the sense that yes, definitely mediation, as I said, and I totally in favor of the motion that it is the way forward, especially into current situation. I just give you example of that a tenant landlord issue of rent payment cannot be resolved through law, court of law. You have to make it go through mediation, through amicable negotiation. So definitely, and you take any dispute for that matter, be it personal or commercial. Even let's say example of check bouncing, which as such is a criminal offense, but it is actually, you don't need that criminal offense tagged to it. Majority of those cases are sorry, are ultimately settled. So why you unnecessarily go through the whole process of a criminal complaint? Employ mediation and resolve it out. That's what actually happens at the end of, let's say, 6 months or a year or 2 years in these matters. So mediation, according to me, has much more wider scope than arbitration, because in our country there are certain disputes which are non-arbitrable, but they can definitely go to mediation. coming to the second part, that do we need any law? Well, in my personal opinion, to an extent, when we talk of any law, you are trying to codify and you're trying to put a boundary, you know, around that particular issue. And according to me, if that boundary is put, then mediation would definitely fail because it will lose its flexibility, just like arbitration for that matter. So I think though we need some structured law for that, but we need to also be very, very clear and very, very conscious not to make it bound within some, technical boundaries. Otherwise, it will lose its importance, it will lose its advantage and over other dispute resolution mechanisms.
So the next question is, so you mentioned that punishment can be option against the party which does not follow the order of mediation when mediation becomes binding. But does that not defeat the whole purpose of mediation? That is coming to the common understanding and understanding each other's interests and feelings.
Can you just repeat that, the first part
Yes,
of the question?
it was said that you mentioned that punishment can be an option against the party which does not follow the order of mediation when mediation becomes binding. But does that not defeat the whole purpose of mediation? That is coming to a common understanding and understanding each other's interests and feelings.
Well, I don't think so because you see, ultimately, the purpose of mediation is not at all punishment. It is that is not at all the issue. I mean, that is not at all the focus point of mediation. The focus point of mediation is amicable settlement. And unless and until the parties come to this kind of a understanding, then obviously the mediation cannot be successful. Now, if talking of punishment, then yes, of course, the whole purpose of mediation would fail. Definitely, yes.
What is holding back mediation in India, and what is the stand taken by India before UNCITRAL in relation to mediation?
Well, I did mention what is holding back, and first and foremost, as I said, is of course the mindset. Secondly, the consensual efforts from all the stakeholders, including the government, the judiciary, people, lawyers for that matter, are involved to dispute resolution, to be to find a common ground and have this kind of a change perspective, looking at each and every dispute. Definitely, and awareness is another part. Training is another aspect. These are the factors which are holding back mediation, uh, you know, in our country for that matter. We definitely need, uh, you know, a pool of good mediators. And of course, we need also good trainers for to train mediators. So, so this is all. These are the issues which the right time to at least try to work around it and promote mediation in a way. And yes, one more thing to this question. I think, and I did discuss that when I said suggest about education. Educating about mediation, and it goes back to the basic change in the curriculum of our law schools in our country, where mediation is not given that much an importance as arbitration. So we need to have at least a good, change, a revamp of our legal education curriculum so far as mediation is concerned.
What is the minute difference between conciliation and mediation?
Uh, you see, these, if you look from a very general perspective, then you won't find any difference as well, because ultimately in conciliation, is what happening is negotiation, and yes, there is also a third party, just like a mediator sitting there. But the basic minute difference would be, I think, two majorly. One, that conciliation is binding. We have a law to that effect. It is an Arbitration Conciliation Act. And secondly, the conciliator has a much more role so far as playing as a judge who do have suggestions to be made to the parties. Then, unlike a mediator who is not supposed to give any suggestions to the parties or judge, make a judgment to the parties, or give solutions to the parties as such. So that I think is very minute two basic differences. Otherwise, there's a very thin line of difference in conciliation and mediation. Most of the time, they both of these processes are molded, together as such.
Why can't we conduct e-mediation using artificial intelligence like China is conducting since 2017?
Well, nobody's stopping you to do that. And just to give you an example, uh, when this lockdown happened, I conducted one, not conducted, I appeared as a counsel in one international mediation where my client was sitting in Philippines because of the lockdown, and the mediator was sitting in New Zealand. The claimant side was sitting in London, and his attorney was in Nigeria. And we did conducted the proceedings online. So there is nothing stopping doing that. And it's nowadays and even earlier also, it used to be conducted, but it was more prominent in arbitration than in mediation. And in my personal view, I think to an extent, online mediation may not be able to give that successful rate of rate of success because you are still not face to face. I mean, you must have read so many discussions taking place about online arbitration, the advantages, disadvantages, all those stuff. But I think those disadvantages are much more to do with online mediation than arbitration because, as I said, it is more to do with emotions, and that cannot happen online. You need to have in person. So there are certain drawbacks, of course, of e-mediation, but yes, definitely, I think that e-mediation now and forth is going to be the future as such.
So the next question is, the central government is trying to decriminalize many economic offenses in different laws. So do you think mediation will play a big role in those cases?
Yes, of course, yes. As I said, mediation has much larger scope than any other dispute resolution mechanism. Unfortunately, the stakeholders have in our country unable to appreciate and give that importance to mediation. And that is why I said that mediation is actually the appropriate dispute resolution process than arbitration or litigation. Definitely, yes, it must play a more important role than any other process.
So the other question is, why Bangalore courts and Delhi have a high number of mediation disputes and success rates in family related cases when compared to corporates?
Which court this is?
Delhi
Why?
and Bangalore.
Ah, yes. Okay. Well, honestly, I really don't have any answer why Delhi and Bangalore have that particular. But yes, I know that these are two prominent centers in our country where the court annex mediation is as in Delhi is working very well. And in Bangalore also, and in Bangalore, in fact, there are a couple of private mediation institutions also which facilitates and also give training into mediation. But as I said, since mediation is much more to do with emotions emotions, feelings of the parties as such. That is why it seems to be more effective and successful in family disputes or matrimonial disputes for that matter, rather than corporate. Because in corporate, you tend to do focus more on your rights and liabilities as such, rather than on emotions and interests of the other side. That is why, as I said, so it ultimately, is what we discussed, and I just what I presented is the difference between sympathy and empathy, and interest and position. If you are able to understand the differences, then I think that will give answer to this question.
What are the important things that we need to discuss with a lawyer while going for mediation?
Well, I think it should be reversed. The lawyer should be discussing things first with you rather than you discussing with the lawyers. But yes, it's a good sign as a party that if you are if you are ready to discuss mediation with lawyers, then the first and foremost thing is make the lawyer understand that it is the party-driven process, is more a party-driven process than arbitration for that matter. So you have to make very sure to the lawyer, and the lawyer must also understand that lawyers in mediation are there to facilitate, not to litigate. All right, that's the basic understanding the lawyer and the parties must have. So it all, and then the important dispute it is. But I think uh, yeah, sorry. Hello.
Yes, sir.
Am I audible?
Yes,
Yeah,
sir.
sorry. So what I was saying that I think the most important part is that um, as a party, you have a you have this understanding and you are appreciating to at least go to mediation. That's the first and foremost important.
Can company secretaries play a role of mediator?
Yes, I mean, as I said, there are no set qualifications. Anybody, for that matter, can be a mediator. Anyone. You need not be necessarily a company secretary. Anyone, for that matter. And you know, it and if you see what in your day-to-day life you see, take example of your dispute between a fight between your friends. What do? You try to resolve it out, try to console them, try to at least take sides and at least do something. So are you qualified? Do you have any qualification? You are a simple student. So there is no qualification. Anybody, for that matter, provided, yes, of course, as I said, you need to at least have the basic experience and inborn skill, as I just discussed, and obviously the understanding of that subject matter dispute as such.
Thank you so much, sir. On behalf of Knowledge Seas, I would like to thank you for bringing on such an insightful session. Thank you, sir.
Uh, Thank you so much, Mega, and thank you to all team at Knowledge Base. And I hope that I have been able to provide some substantial and good information and knowledge to the participants. And I look forward to much these kind of discussions in future. Thank you.
Thank you, sir.